the appellant.
Welcome, Ms. Brown.
Aubrey Bisbee for the state.
Welcome, Ms. Bisbee or Brisby?
Bisbee.
Bisbee. Welcome, Ms. Bisbee. You're both veterans of our court. You heard the speech before. We allot 15 minutes per side per argument. There's a clock on the podium. It works backwards. If you're at zeros and we're still asking questions, feel free to keep answering. If there's no questions and you're at zeros, it's probably time to wrap up. Are there any questions before we begin?
No, Your Honor.
Okay, we'll hear from Ms. Brown.
May it please the court, Wendy Brown on behalf of the appellant. The waters have been muddied a bit, but this appeal is actually relatively straightforward. There's two issues here. First, the district court did not apply the proper standard in determining that Mr. Stubbs was a danger. Second, it failed to consider available pretrial release conditions. This court can reverse for either or both of those reasons. As to the first issue, nowhere in the court's verbal or written order does the phrase substantial danger appear.
Doesn't the court make something of an implied finding to that degree? I mean, the court repeatedly talks about what it perceives to be the danger of him with his propensity for sexual offense against children. I take your point. I looked, I didn't see the phrase substantial danger anywhere in its findings. But when the court repeatedly talks about danger writ large, why wouldn't we tap into that line of cases that say that we can find that a court has made an implicit finding and call it good?
Because I think that, as a starting point, bail is a constitutional right. The bail statute has to be applied very strictly. And the language that our legislature chose to use is substantial danger. If the legislature thought it was enough that if someone was a danger, they could be denied bail, the legislature would have said that.
I mean, at one point, I went through the transcript, at one point the district court says that it thinks that the state has put, I don't know the exact phrase, but the word I have in quotation marks is compelling. It says it uses the word compelling. Isn't compelling essentially the equivalent of substantial?
No, it's not. I don't mean to parse language here or make this too complicated.
I think I've invited you to parse the language. So.
The language is substantial danger. And I'm not saying that given the discussion, the court couldn't have eventually maybe reached this determination. The error here is that the court did not make a substantial danger determination.
So are they...
Go.
Sorry, are they magic words in your view then? So the court has to say on the record, substantial danger as a phrase, those two words together, or it's an error, period,
Yes.
End of story.
Yes.
Okay, so there's nothing short of uttering those words that will get a trial judge to the level of having met the standard of the bail statute.
I mean, I'm not going to say that there's not ever a possibility where we couldn't say, well, he said substantial in the sentence before and then danger in the sentence later or something like that.
But you are saying that those two words have to be there.
Yes.
The word substantial in particular.
And more than that, the statute isn't just substantial danger. It's clear and convincing evidence of a substantial danger. Clear and convincing evidence doesn't appear in the court's order either. So
It seems though that, if I remember right, the court references the correct statute, does it not?
it does.
If the court has referenced the statute, isn't it clear that the court knows what those magic words are? And when it says, I find that you've not met the standard in the statute, that those words are incorporated into that finding as a necessary implication?
I'm not sure that's true because under Section 201, there's so many different variations of how we determine bail. And if you go back to the initial bail determination here, the state made the argument that this is a qualifying domestic violence offense that could be denied bail. Then the court didn't consider that or rule on that point. But I think that kind of introduces this idea that we're working under several possible subsections in the statute. And because the district court didn't ever say, I need to find clear and convincing evidence of a substantial danger under the statute, and then later said, I find that we've met the statutory elements, that would be a different case, of course. But because 201 is just so broad, it covers many different offenses, I don't think that the court's ruling or discussion anywhere is clear enough to make us sure that he was talking about all of the subsections under subsection C. And again, I just would remind this court, we're dealing with kind of layered issues here. A constitutional right to bail, clear and convincing evidence, substantial danger. We're missing all of this. And we're not asking here for a reversal of a conviction or anything. The cost of a reversal here is a remand proceeding to be done correctly.
Okay, so I want to make sure I understand that answer. That was on my list to make sure I pinned down. I think you just answered it though. So if we agree with you that there needs to be a finding of substantial danger, and we agree that there was not such a finding, you're not asking us to send back with orders for him to be released. You're asking us to say to the district court, in essence, you got the analysis wrong, redo.
And I would ask specifically with a direction to consider the statutory language, clear and convincing substantial danger, after considering pretrial release conditions.
Do you view clear and convincing evidence as magic words again? So could a district court say, I found that the evidence meets the standard of the statute without saying clear and convincing evidence explicitly?
I think that could happen, but here we have something far less than that. The state alleges that Mr. Stubbs is a sexual predator, and in making its determination, it's a verbal ruling. The court says something along the lines of, I am concerned by the state's allegation that he's a sexual predator. Now, I don't know where you get that, but it's hard to unring the bell. I don't know where you get that, but it's concerning, is not clear and convincing evidence. And so, again, I'm not saying that there's not a chance that we could be thorough enough in our analysis and the evidence that was presented that maybe we can say, okay, the magic words were missing, but we remain confident that the constitutional right to bail was properly denied. We just don't have that here because we have in the defense counsel's words, and I think they're accurate, the state's proffers, many of them are hyperbole, right? For the county attorney's office to say, this is the most the most severe case we've ever dealt with. I'm sorry, I just don't believe that. And I think those are the type of red flags in the hearing that say that this doesn't rise to the level of clear and convincing evidence.
I have a question about the 24J letter and the potential for mootness. And initially, I have a question in your response to that in saying that that the order attached to the state's letter is not a new no bail order. It granted or denied no motion. It followed no hearing. I went and looked at the trial court docket. It looked like there was a motion and there was a hearing. And the order itself says there was a motion and a hearing. So can you just clear that up for me first?
The order specifically references that September 27th hearing, which is the same hearing that we're here about. And I think maybe talking about the timeline of events could help clear this up. So the parties appear for a hearing on September 27th. State files a proposed order on September 30th. Defense objects, files their own proposed order. The court looks at everything, says, I don't need more argument. Here's my order, files that on October 31st. For some reason I cannot glean from the record, on December 27th, the same day we file our reply brief, the state files their exact same proposed order that they filed back on September 30th. At that same time, there was a proposed order as to 404C proceedings that were happening. It could have been an accident or an oversight. The parties have hearings on that 404C motion. Again, there's this 404C order that's signed on January 13th. The order attached to the state's 24J letter bears that same January 13th date. And it's confusing at best, but I think what's helpful for this court is to recognize that the only difference between these two orders really is discussion about what the individual parties argued. The state's order remains the same, and if it's helpful, these are the two orders side by side. This part that is not repeated in both is just the state argued, the defendant argued. This and this are virtually identical, and that's the court's actual order.
That was very helpful. Thank you.
Maybe this is implicit in the answer you just gave, but there's that passage in Graci, is that how we're gonna say it?
I've been saying gross, but I have no idea.
I was gonna go with
Gross
Graci.
works for me.
Okay, gross. That talks about how even though subsequent order doesn't necessarily moot a challenge to the prior order in the bail context, the defendant has the ability to file an amended appeal or a new notice of appeal and they get consolidated. Do we need some mechanism like that to get to this latest thing or no?
No, so I think starting in the language of the section 207 helps. Only upon a showing of a material change of circumstances can there be a reconsideration. So at the very least, there's no jurisdiction on the district court's part to enter some new order. Again, the substance of the orders also informs this decision that this is all based on that same September 27th hearing. And then I think on top of that, because this is necessarily an order as to the September 27th hearing, at the very least, Rule 4 says that our notice of appeal covers that. On top of all of that, Gross, in talking about mootness, says that even when there are subsequent orders, whether appealed or not, so long as the issues remain a live controversy, and here that's what we have, Mr. Stubbs is still in jail, it's still a live controversy before the parties, then the issue as to the propriety of the entered order is not moot.
As I read Gross, it could become an issue. There's potential for mootness if this were a new order, but from what you've explained, it sounds to me like this might be best read as a restatement of the original order, but that we don't really have a new order, at least not on a new motion.
Yeah, it is my firm position, this is not a new order. And I think in Gross's discussion of mootness, where something might become moot with a subsequent order, it specifically talks about the case has been resolved, whether it's by plea or jury, and then the question of pretrial release is no longer ripe for review.
But and this point may be moot in our discussion now, but if you have a subsequent order that does hinge on finding that there has been a substantial change of circumstance, and now we're looking at a new set of facts, that may moot an earlier order that is based on a different set of facts.
It could, yes.
And that's why here with what I'll call the restated order, saying even if there was a substantial change of circumstance, I'm finding that the statute is met. I viewed that as potentially that circumstance where the court's saying, okay, well, let's assume there is a substantial change of circumstance. I still find the statute met, that potentially could moot the original one, but we're talking about the same facts and the same motion.
Same facts.
So I think I'm on the right.
If I could help also, in Your Honor's opinion in Taylor footnote 1, it refers to a material change of circumstances as a prerequisite for the court deciding bail. And I would just say nothing was ever proffered, nothing appears in the record that there was a material change between October 31st and February 3rd.
Was there any motion to reconsider
No,
presented to the district court?
no.
This January 13th, 12th, whichever day. This order, it just pops on the record as best
literally just
you can
appears.
tell.
Correct.
And the hearing that it references is the hearing on which the notice of appeal was filed.
That's
So,
correct.
curious, I think is maybe the best way to describe
I
it.
think it is confusing, but I think this court can compare those two orders and rest assured they are both dealing with the exact same issues. The new order, if you want to call it that, doesn't cure any of the issues raised on appeal. It too does not use the phrase clear and convincing evidence. It too does not use the phrase substantial danger.
And most importantly, it's based on the same
It
evidence.
is exact same facts.
Can I take you off of that issue, unless we have more ground to cover on that? One of the sort of next tier findings the court has to make, or take that back, that verbiage. The statute talks about how the court has to consider the available conditions of release before making the substantial danger determination. Do I have that right?
That's correct.
Okay. And you say that in your view, the district court did not consider the available conditions of release. Here's what I've got the district court saying in the initial oral ruling, quote, I would find it hard to let him out to a family where his stepson is back in that family until after these cases have been tried, which seems to suggest the court's thinking about the possibility of letting him out and how it would do that with the stepson angle. And then after that, after the court sort of seems to announce its ruling, then I can't remember which attorney brings it up, but one of the attorneys brings up, hey, you haven't really talked about the conditions of release, and they have a back and forth about that issue, at which point the court denies the motion to modify again. So I take your point that the district court doesn't say on the record, I've considered and rejected all the potential available conditions of release. But if we've got this whole discussion of it, and the court's a participant in the discussion, and then the court denies it, and the statute talks about consideration, why haven't we checked that box?
Okay, two answers. When the court is saying I might find it hard to release him to the same house, I think this demonstrates the problem with the court's failure to invoke the right standard, because that might go to if there's a substantial danger to an individual, whether or not that he can be kept away from that individual.
Yeah.
But then the only danger determination is he's a danger to society. So I think that kind of highlights the problem that even in kind of discussing if he would be released to the home where the alleged victim was, it's unclear even what part of the statute he's deciding this under. And then also I would push back on the court's use of the phrase back and forth about the available conditions of release. After the court announces its decision, defense counsel says, can I make a record, presumably for appeal? Mentions in there available conditions of release. The court says, I'm just wondering why this wasn't brought up before. State, what do you think? The state says, of course, no, this is the worst person in the world. We're not going to let him out.
Well, the state, in that passage, correct me if I'm wrong, but if I remember right, in that very passage, the state says something effective, I can't conceive of a condition that would protect everyone.
And that's the state's position, but the statute says after the trial court has considered all available conditions of release.
But why
And I-
can't we presume if there's, not to cut you off, I'm sorry, but
Well-
why can't we presume that if there's a discussion and the court's sitting on the bench, that the court's listening?
Okay, so number one, not a discussion. They did not address specific conditions of release. Instead, the court abdicated this discussion to the attorneys. The court was not involved, and more specifically to the state. And then I think more telling is the fact that the court says, if you can come up with a stipulation, I don't need another hearing, just get that before me. That alone indicates that the court was not so closed off to the possibility of release that it wouldn't consider
But
it.
that's not the statutory standard, though, because the statutory standard is that there has to be consideration of conditions of release. And so if the court is saying at the end of all that, I'm about to cough, sorry. If the court is saying at the end of all that, nobody's convinced me that there's a workable condition of release, but if you guys can come up with one, I'll revisit. Why isn't that
If
at least
we had
consideration?
that from the court, I think I might agree with you. Nobody's convinced me that there's a workable condition of release. The court does not go there. It says, why didn't you bring this up before faulting the trial court, which that is error because it's the trial court's job. Then it refers to the state and says, what do you think? The state says, no, nothing. We're not going to talk about any conditions of pretrial release that we think would work. Then the court says, okay, my order stands. If you can get a stipulation, put that in front of me. So the court isn't in this back and forth. The court doesn't make any
But
reference to
why can't we presume he's thinking about it?
thinking about what?
Thinking about this discussion that's happening in front of him.
But there were no conditions of pretrial release put before the court. I think that's the problem.
But the parties are taking sort of diametrically opposing positions at that point. The state's saying there are none, like full stop. And the defense counsel, I take your point. The defense counsel is not proposing any.
Right.
But
I'll just add on to that. Does timing matter here? Because I understood your argument to be that the court had to consider the conditions before making its determination, and this discussion happens after the order's been given, right?
I mean, technically, the statute says after considering available conditions of release. I don't know that that's where this argument lives or dies. I think that if we have the announcement of the order, we have a full discussion about possible conditions of release, and the judge says, I'm convinced that none of this will protect the community. I don't know that that language of after necessarily means that that's not okay on the district court's part. My position more, and I think I hope the briefing fleshes this out, is that consideration simply never happened. It made its order without considering pretrial release conditions. When it was mentioned, the court faulted defense counsel for not bringing it up and deferred to the state, and that just doesn't meet the standard under the statute.
You're at zeros. I want to make sure there's any lingering questions. Seeing none, you'll get your full rebuttal.
Thank you.
Your Honors, Counsel, and may it please the Court, Aubrey Bisbee for the state. I'm excited to be here today to present my first argument to the Court.
I was wondering that. I didn't recall seeing you, so this is your first argument.
Yes, it is.
Welcome.
Okay, welcome.
The Court should dismiss this case for lack of jurisdiction or alternatively affirm the District Court's order for 3 reasons. First, the expedited bail appeal statute only applies when the District Court issues an order denying bail, which is not what happened here. Second, this case differs from gross and significant procedural ways, which ultimately deprive this court of jurisdiction. And finally, if the court decides that it does have jurisdiction, because the district court never found a material change in circumstances, the court should affirm the order. So moving to the expedited bail appeal statute.
How does it, let me just take you to the second one. How does this
Yes.
differ from Gross? Because it feels to me like Gross answers the first bullet point you just gave us. Gross seems to say that a denial of a modification motion can be appealed. So you're saying Gross is different. That's what I understood to be your second point. How?
There's two big reasons. So first, in Gross, you had an appeal from the initial pretrial order denying bail where the court went through the full 201 analysis, and that's how that appeal began. And then the modification order was added on, so it was an expansion to that appeal. And then second, the modification order in Gross resulted from a preliminary hearing where new evidence was presented, and so the court was reevaluating whether there was substantial evidence supporting a denial of bail. So it was based on, that modification order in Gross was based on new evidence presented at a preliminary hearing and new findings based on that evidence that was presented. And here, we don't have an appeal from the initial order, and based on, we only have the transcript.
I'm looking at Gross, not putting on the spot, but I'm looking at the end of paragraph 36 from Gross. Thus, this is what the court says, quote, thus a defendant may appeal not only the original pretrial detention order, but also subsequent orders in which the court keeps the defendant in pretrial detention. It doesn't insert the qualifier that I'm hearing you suggest is what matters. It doesn't say there in that sentence or anywhere in that paragraph that I see, if there has been an appeal from the initial one. Am I missing something in Gross that makes that determinant in some way?
So it's not necessarily that they didn't appeal the initial one, it's that this isn't an order denying bail. And the court does use that language in Gross about a pretrial detention or an order that keeps the defendant in pretrial detention, but
Right.
it also uses the language from the statute about an order denying bail. And I believe there is a difference there. An order denying bail, which is what the statute refers to, is one where you make those findings under 201, and there's an order that is operative that denies bail.
When you seek reconsideration based on changed circumstances, the underlying request in that is grant me bail. And then when that gets denied, you've been denied bail. And isn't that, and that you're making a very technical linguistic differentiation that I agree, that last sentence of paragraph 36 of Gross seems to resolve that when you make a motion to modify, that's denied, you've been denied bail, have you not?
So a motion to modify is different from seeking bail at the outset, for a couple reasons. So in a motion to modify, you have to first make that showing of a material change in circumstances, and then the modification statute 207 says that once that's made, the judge may modify bail. And so you're working in that scenario from a standpoint where the court has already made the 201 findings. So those findings already exist out there, and now it's the court's job, once there's been a showing of a material change in circumstances, to look and see, has there been anything that's happened that changes those findings that I've already made? And I mean, in this case specifically, the prosecutor says at the outset of the hearing that the court has already decided under 201 that the defendant should be denied bail on at least 3 occasions. We don't have transcripts of those occasions, so we don't know what those findings looked like or how they may have changed, and that is an issue here. But when you're dealing with a modification, you are working from a baseline of there's already been that finding under 201. So moving to does the court have any more questions about the jurisdictional arguments?
I have a question about the 24J letter and what I called the curious situation
Yes.
that happened. So is it the position of the state that there has been an intervening motion made by the defense, whether it was captioned however, to reconsider the original or to consider again his conditions of detention, that is a new order from the court deciding a new motion, and thus the motion that was appealed has been superseded, for lack of a better word?
No, I agree with defense that it does seem that order it's hard to tell where that came from just looking at the docket. And as the state said, we don't believe that order actually changes anything because we don't believe that order or the order on appeal is actually appealable under the expedited bail appeal statute. But the reason we brought it to the court's attention is because of that language in Gross about that a defendant needs to appeal every pretrial status order they intend to appeal. And so we thought that it'd be best for the court to be aware that that order was lingering out there. With that, I will move to the no material change finding. The court makes a finding of no material change in circumstances, both in its written and oral rulings. In the written order, it uses the language even if, which implies a counterfactual, that it's not finding a material change in circumstances. And interestingly, in Gross, one of the orders.
Yeah, sorry, go ahead.
No, go, I'll defer to you.
Doesn't the district court actually say on the record, though?
I'll turn to
I
that.
found a material change, that's why I'm even allowing this hearing to go forward?
So the court does say that, oh, sorry, I'm turning to the wrong thing. But then a page later, it says, so I don't believe there's been a change in circumstances. That's at the bottom of page 40. And it seems clear from the full context of that quote from page 39 is the court saying, I've allowed this hearing to go forward because I think there's a chance that there was a material change in circumstances here. And then it goes on to elaborate its findings.
But the
and
court
it
seems
says-
familiar with the statute, not to cut you off, but the court seems familiar with the statute. And the court seems to understand, I think, that it needs to find a material change in circumstances before it would get to the substantial danger inquiry. And so when the court says, back to that even if passage, when the court says even if, or more to the point, when the court says, quote, that's why I've allowed this hearing to go forward, isn't one reading of that phrase, that's why I've allowed this hearing to go forward? The court is saying, I have to have found that there was a material change in circumstances, which is why I'm about to do the rest of this thing.
Well, that's the very argument the defense counsel makes at the outset of the hearing, and the court pushes back on. So the defense counsel tries to say, we're here because you've already decided there's a material change in circumstances, and the court says, no. We're here for you to put on evidence that there's been a material change, so let's move forward with that portion of the hearing.
But then why would the court make any additional finding at all?
Yeah.
If there's no material change in circumstances, that's the end of the inquiry, and the order at the end of the hearing need only say, I find there's no material change, period, end of analysis. But the court here goes further than that. Now, defense is saying not far enough, but certainly makes some findings beyond just the materiality issue.
Yeah. And I think there's a couple reasons why that may be. The court seems to be saying, and whether this is proper analysis or not, it seems to be saying that there is no unreasonable delay. And even looking at the full context of what's happened in this case, if there were an unreasonable delay, it's hard to see how that would change the underlying 201 findings that the court has already made. So it kind of crosses over into that
I think your
analysis
view,
a little bit.
not to put words in your mouth, your view is it seems to sort of skip past the issue because it thinks it can resolve this on the other grounds, right? Or
I
is
don't
that
know.
wrong? Yeah.
I don't know if that's quite right. I don't know that it skips past the no material change. I think it did find a no material change, but it's sort of almost offering some comfort to defendant that, look, even if there were a material change, I just don't see how there's been a change to the underlying considerations for bail here.
But I mean, the whole defense argument, as I understand it, is that the material change in circumstance at issue was the length of time that he had been incarcerated. And the court, in several places in the oral ruling, and again, and it's a shorter written ruling, but the court makes a point of saying that it thinks that there has been a really long delay, and that it's buying some of what the defendant is selling in terms of that being problematic. Fair?
Yes, I mean, the court is concerned about the period of time, understandably, but it doesn't make that finding of an unreasonable delay that's not attributable to the defendant in the end. In the end, it says, I'm attributing the delay to both sides, and it doesn't find an unreasonable delay.
But it goes out of its way at one portion of the oral ruling to he specifically delineates a couple of sources of delay that have nothing to do with the defendant. One of his attorneys had died, one of the prior judge had been appointed to the federal bench. And so isn't one reading of that passage, by identifying those things that had nothing to do with the defendant, the court is saying, hey, you're not responsible for some of this delay that I'm concerned about?
I mean, I think the court is saying, I'm not holding you fully responsible. I mean, they say they're attributing to both sides, but it's also not saying there's an unreasonable delay that we can't attribute to you at all. I think it's saying that, look, these are delays that happen in cases, and I agree that I'm concerned about the amount of time here, and let's get this case rolling.
Yeah.
But in the end, that's not an unreasonable delay that is wholly not defendant's fault.
Let's suppose we get past those initial hurdles, and we get then to this question of whether the court needed to make a finding that there was clear and convincing evidence of substantial danger. I haven't seen that the court use the phrase, either of those two phrases, clear and convincing evidence or substantial danger. We're being told from the other side that's problematic. I take it you disagree with that. Why?
First of all, I think it's looking for magic words in the order, and it's all there by implication. The court's referring to the statute. The court is saying that he's a sexual predator, that there's compelling evidence that he presents a danger. It's all there by implication. And even going further than that, as I was kind of saying earlier,
Can we even do a finding by implication analysis in this context? The other side's pointing out, I think correctly, that this statute is really specific. This statute from the legislature says that the court needs to find by clear and convincing evidence that he's a substantial danger. So why isn't this scenario one in which we would take the legislature at its word and say, it meant what it said, there has to be this particular finding, full stop? Like, where would the authority be for us to say they don't actually have to say that?
I believe, and I don't have the cases off the top of my head, but there are cases saying, look, you don't have to use the exact wording in the statute as long as you meet the standard that the statute gives you. But going even further than that, this is a modification hearing. And as the prosecutor points out, the court had already found on 3 different occasions that they'd met the standard under 201 to hold the defendant without bail. And again, we don't have transcripts of when that happened, but the court's saying that happened. And so
is it your position then that a modification hearing would be different in that regard than an initial hearing, such that the magic words, as I've called them, would be necessary in the first hearing but not in subsequent hearings?
I don't know that they would be necessary in the first hearing either, for the same reasons, as long as you get to that standard substantively, the words themselves, don't matter as much as long as you meet the standard substantively. But it is different in a modification hearing because you're working from that baseline of the court has already made the determination under 201 to hold this defendant without bail.
So you're asking us to hold that in this context, we can sort of incorporate the prior findings of substantial danger, that should sort of presumptively just sort of stay with the case?
Yes, and I think that's correct. It's following through with this case, right? That is the order that's holding Mr. Stubbs without bail. That is the order he challenged. And so that's what's holding him.
Do we know that the initial one was based on that subsection of the code?
We don't have a transcript, so we don't know exactly what was said or presented at that hearing. All we have is that on the docket it says that the detention hearing was held in January of 2022. So that's all we have.
Suppose we get past that hurdle. This case is a series of hurdles, I think. What's your best evidence that we could look to and point to that supports a finding that he's a substantial danger? If we write this up, I mean, I know that there's this discussion of he might have molested people when he was an adolescent. There's this discussion of this thing that happened 5 years earlier. The record's a little bit fuzzy to me, at least as deep as I've gotten into it so far. Like, what's the evidence as opposed to the allegation? Like, what are we pointing to that says this evidence thing tells us this? Like,
Yeah.
what's that?
So, I mean, just looking at the court's oral ruling, they say, I'm concerned about the state's allegations that he's a sexual predator. They say, I'd find it hard to let him out to a family where his stepson is back, so expressing concern about the safety of an individual in that situation. And then they also talk about the state's allegations that he's a danger to society, that the court is essentially buying that. So it's talking about danger to an individual. It's talking about danger to the community. And then again, in its oral ruling, it makes kind of similar assertions there. Okay. If there are no further questions.
You still have 20 seconds, but.
That's all right. I'll ask the court to either dismiss the case for lack of jurisdiction or affirm. Thank you.
Great, thank you. Appreciate your argument. Look forward to many more years to come. Ms. Brown, you have the final word.
May it please the court, Wendy Brown for the appellant. I want to start with jurisdiction. Utah Code Section 7718A1, subsection 1D, specifically says the defendant may, as a matter of right, appeal from an order denying bail under Chapter 20. That's broad enough to encompass 7720-207. That decides the issue of jurisdiction. Additionally, of course, Section 209 within Chapter 20 says the same thing. Also, the fact that this court reached the merits in both Gross and Taylor indicates that this court has jurisdiction to consider appeals from modification orders. I'm a little bit confused why the state continues to say we don't have transcripts from the prior bail determination. We do. January 4th, 2022 transcript was prepared and submitted to the court. On page 8 of that transcript, the court said that this was a very difficult call. So insofar as that initial bail determination weighs at all in the court's deciding of the most recent hearing.
Well, here's what I'm struggling with on that. I take that point. If the court has made a finding in the past that he's a substantial danger, and if we've gotten through this material change in circumstances hurdle, and now the court is looking again at whether he's a substantial danger, don't you, from your end of this thing, have to point to something that makes him less dangerous now to get through the previous finding that was unchallenged?
Yeah, and defense counsel did that. Throughout the DCFS proceedings, Mr. Stubbs was completely compliant with every thing placed upon him by the juvenile court. There was a proffer that he was a model inmate as to jail. Now the state contests that, but without any actual proof. There's no evidence that he's written up for any, breaking the rules in jail. So for these 2.5 years, Mr. Stubbs has indicated that he was willing to follow rules placed upon him, which would indicate that if the court had undertaken the pretrial release conditions analysis that it needed to, there was evidence that Mr. Stubbs was willing to comply with the conditions placed upon him. I also want to remind this court that on none of the substantive issues did the state respond. That makes our appellate burden lower as long as we've put forth a plausible basis for reversal on either the substantial danger issue or the pretrial release conditions. This court should reverse, and we've made that showing. And as to the magic words, I just think that while there are other situations when magic words aren't required, none of that case law is in the context of bail hearings. None of that case law is talking about a very important constitutional right.
But if we've got case law in other contexts in which we don't require specific words, even if they're in statutes.
Because none of those cases say, this statute says you have to find A, B, C. You didn't say A or B or C, but we're going to find it enough. The state didn't brief this issue, so we don't have the benefit of any of the case law just alluded to. But even if we're talking about some of the conditions where we say we don't require magic words, I would argue that those have to be in situations where the statute does not include magic words, and the statute here does.
And thinking about another statute like in sentencing, right? So a district judge is required to consider certain things in sentencing, but we have lots of cases that say you don't have to say that out loud, right? You don't have to say on the record that you considered the things itemized in the statute that you have to consider. So it strikes me that this is a similar circumstance, right? How is it different than
If my
sentencing?
argument on appeal was that the state didn't specifically say everything in section 205 as to what pretrial release conditions existed, that would be analogous to sentencing statutes, because the sentencing statute says consider these things. 205 says consider these things. If I was arguing he didn't say 1 through 20 of that, those are the magic words, then that's closer to the sentencing situation. That's not this. This is, we're requesting that district courts make a very specific finding, substantial danger. The district court found danger. Those do not match up. Substantial has to be given meaning by this court.
I want to come back to my question to you earlier about why can't we imply that from the reference to the statute? And as I've gone back and looked at 201, it seems like, it goes A through H, as you're right, there's many different variants, but some of the, all but 2 of them, it's clear would not apply. Capital felony, this isn't a capital felony. DUI, it's not a DUI. It's only a substantial danger to an individual or to the community, or the other one, domestic violence, but still substantial danger to the alleged victim of domestic violence. So just by context, either of the 2 possibilities require a finding of substantial danger. And so given these facts, I want you to answer my question again. Why can't we infer from the fact that the court found that the statute was met, that it found substantial danger, since the 2 subsections that possibly could apply both have that substantial danger.
I think that the
Language.
court's only reference to the statute was when it said, first I need to consider whether he's a flight risk, and I don't think that he is. That he put in terms of the statute. None of the rest of the court's order says that. I also think the fact that this order is kind of vacillating between its 404 determinations, which was also pending before the court, and the bail determinations, we just don't know. And that's why I go back to this initial point of the cost of reversal is a new bail hearing. The right at issue is constitutional. And because substantial danger has to be something different than danger, otherwise the legislature would have said danger, we just don't have a finding from the court on that point. And again, I would remind this court of my lower appellate burden because the state didn't respond to the substantive issues raised.
One last point, because we haven't had long enough arguments today. It's back to two other pieces before. So if you have an initial bail determination, the court makes the substantial danger determination. And then the defendant files a modification motion a couple months later, as opposed to 2 years later, which happens here. Is it your view that the district court each and every time has to use those words?
Yeah, and
I'm thinking through analytically how we would write this if we go your way. So let's say, I can start constructing the sort of absurd hypotheticals. What if it's a month later? Nothing's really changed, but the defendant's come up with some good sort of change in circumstances, but nothing's really changed the danger part. I can imagine a bunch of district court judges reading our opinion and going, I just said that. I forgot to say it again. And I'm wondering how problematic that's going to be.
so if nothing had really changed, then there wasn't a material change in circumstances.
If we write the opinion that I think you're asking us to write, where we would say each and every time the district court has to say, I find by clear and convincing evidence that it's substantial danger, I can envision a bunch of scenarios in which the district court sort of forgets to do it because it was so close, and now we're doing sort of unnecessary reversals on that point.
So I don't think that this court's opinion has to say that. I think it can say, in this case, the court didn't make a substantial danger finding, therefore we reverse. I also think that the language of 207 saying only upon a showing of material changes of circumstances insulates district courts from motion upon motion upon motion when nothing is changed, because there has to be a material change in
They're
circumstances
just going to deny it on that first part.
Exactly.
Yeah.
And so if there's evidence that the danger element has changed, which defense counsel proffered here, we need to re-engage with that analysis and decide whether the defendant is a substantial danger.
Okay.
If there are no other questions, we would ask this court to reverse.
Another question? No further questions? Okay. Thank you for your arguments, to the both of you. It was a well-briefed and well-argued case. We will take it under advisement and issue a decision as soon as we can. And with that, we'll be adjourned for today.